Howdy. This is my second and hopefully final attempt at getting a video for the second part of Chapter 5. I recorded an awesome video and then had Camtasia somehow eat it. Kind of reminds me of an incident that happened in '95. I was in Japan, and I was out on the western part of the main Japan and heading back to Narita, Tokyo, and as a plane came in for a landing, something bad happened. There was a video monitor, believe it or not. We could see the lights of Tokyo, and as we came in for a landing, the pilot had to abort the landing and shut off the video. And we shot back up in the air, and there was screaming and crying and people yelling in a language I obviously did not understand. True to my nature, although I'm a very excitable person, the first thought that hit my head was 4 Americans among the dead. But we circled, and they said in Japanese, and then they said in English, in a few minutes we're going to come back and tell you what happened. And, and they never did come back and tell us what exactly happened, but they said something in Japanese, and then the Japanese stewardess very nicely said in English, and now we are going to come back and make another final landing. And I was the only one that kind of laughed, because the fact it said, I don't know, another final landing just kind of struck me as being funny. So I guess another attempt to capture video 2. I hope I can remember all the ones that I imparted the first time of something that is now floating out in the ether sphere. So video 1 was about CFAA, and I said we were going to review it, and we're going to continue to talk about CFAA through the rest of the semester. Now I'm sounding like somebody's mother or, God forbid, grandmother, but you need to read this chapter. I selected this book because it is very readable. The disadvantage of this book is a lot of times I gloss over the legal stuff because I'm not training you to be lawyers. Jeff Kosseff, who wrote this book, intended it for 2 different audiences, law school and non-law school. You're non-law school. What I found out recently is his syllabus is completely different than mine in that he treats his cadets at the Naval Academy, who are undergraduates, as wannabe lawyers. He has them present cases in front of judges. He has them do what we call issue spotting. If you want that kind of class, I suggest you enroll in the Naval Academy because, God forbid, we don't need more lawyers. What we need are knowledgeable cyber workers. So that's my goal here. So we ended with CFAA. There was one thing I did not note. On the bottom of page 197, the story of Lloyd Drew. And this is a very sad story of an adult that shouldn't be an adult. That led to a child's suicide, and they could not find a law to prosecute her, and this is what happens. This is a cyberbullying attempt. They attempted to bring her into the CFAA. They could not prosecute her, so they, of course, changed the law, but this is when I say law always lags technology. Lloyd Drew was the casebook, classic case of this, a totally reprehensible person in my book. I gave a talk last November on cybersecurity and laws and the state of that in the U.S. And now, of course, we've got a lot of them, I think, in all but 3 states. And a lot of it is, again, a crime happens, but we can't fit it into our existing framework. We try to force a lot into CFAA. We try to do things that didn't work. We pass the laws. Sometimes they work, sometimes they don't. So that is my long-winded introduction to DMCA, the Digital Millennial Copyright Act. And I want you to be sure and understand a couple things about this as we go through it. First of all, this is a law that you will be hit over the head with if you are doing software. If you are doing any kind of software out on the research or development area, you're going to be talking about or being held to DMCA, okay? We're talking about Section 1201. I believe it's Appendix C that has Section 1201. The Digital Millennium Copyright Act is much bigger than that. If this lecture wasn't going to run over probably 30 minutes, I'd go show it to you on the web, but I know your intellectual curiosity will take you there. Important thing is it implemented WIPO treaties, World Intellectual Property Organization treaties. So what does this mean? We're a country. We expect to be treated certain ways. Other countries expect to be treated in certain ways. We sign these treaties, and then Congress has to sign off on the treaty, and then they go back and say, okay, now to be in compliance with this treaty, we're going to have to change our laws. And that's was DMCA. It extended the reach of copyright to online resources. It did not change U.S. copyright law. It extended it. It created new grounds for liability based on that law. It, quote, does not create a new property right, which, if you want to be a lawyer, will just keep you up nights in interesting debate. Property rights we call a bundle of rights. You see this in real estate in Texas. I can own my house, but I don't own the mineral rights. That's a bundle of rights. I own certain things. In some states, you can actually own the building, but not the land the building sits on, and you sign a 99-year lease. This is very common, I believe, in Honolulu, Hawaii, and because of their state laws. So property rights, it doesn't create a new property right. In other words, it does not enlarge the property right of the copyright owner, supposedly. There is conflict on this. There is debate. Does it? But the important things, this was to implement a treaty. This was to extend the reach of copyright to online resources, and it is based on U.S. Copyright Act. Doesn't change our law. All it does is bring this into the new millennium, supposedly. It also creates both criminal and civil causes of action. Now, here's what I want you to take away from this. And I'm going to do a video sometime and make it available to anybody that wants to do it. I do it for my digital entrepreneurship class. I do it for the engineering entrepreneurship class because I am a licensed patent attorney. There's only 33,000 of us in the United States. It's the only law license that requires to have a federal license, and you have to pass the test. The USPTO is just what it says, United States Patent Trademark Office. USPTO, patents and trademarks. Well, gee, who manages copyrights? Copyrights are managed by the Library of Congress. Okay, and in our third section, when you're on the edge of your seat, it's going to be on trademarks. So the question would be, who manages trademarks for the United States? And the answer is no one. They are managed by the trademark owners. All right, so, I got to stop making errors in my slides here. So let's just flip over to page 209. Because I wanted you, as you probably read this, you probably thought, wow, wait a minute. We caught this licensed attorney and this licensed patent attorney and this licensed engineer professor of ours in a big, fat problem because she's shown us a map that shows 11 circuits, 11 appellate districts set up that are called circuits in the United States, and she's painstakingly repeated, like we don't understand, that you can have a conflict of interpretation of federal law in those 11 circuits. But on page 2009, there is a U.S. Court of Appeals for the Federal Circuit that doesn't show up on the map. What's with that? And I would say you're right. I glossed over that because this is a very odd court. It's the only federal U.S. appellate court whose jurisdiction depends on the subject matter and not the geographical location, the subject matter. And if I am prosecuting patents and my patent is denied for either violations of 101, 102, 103, novelty, prior art, or obviousness, and I want to appeal, I've got a couple of different options after I go through the process of appealing through the USPTO itself, and one of those options is for me to take it to the CAFC. I can also take it actually to the other appellate courts in Virginia. However, why would I want to take it to the CAFP? Because all they do is IP law. Their jurisdiction is on subject matter, on certain IP subject matter. So, first of all, that's on the page of 209, and he talks about a narrow interpretation of a certain part of the DMCA, which we'll talk about in a minute, A2. So that's one thing you probably caught me in. Second thing you might have caught me in is the top of page 210. It mentions prima facie case. And, of course, you're being good students. You Googled this. And you found out that this is a first impression, and it has to do with burden of proof. So this is how this works in this case. Either the plaintiff, or in some cases the defendant, depending on the particular process we're talking about, has the obligation of proving a prima facie case, and that means on the face. Doesn't mean it's doesn't mean it's more likely than not. Will it pass in a civil court? No. It's just on the face. It looks as if they've proven all the elements. Now, if I'm the plaintiff, as you will see on the bottom of page 209, to bring an action, I have the burden of proof before the case can go forward to prove the first 5 of 6 elements of A2. the defendant can still prove I was wrong. For instance, one of the elements is I had a valid copyright. Well, let me tell you, the first thing it's going to do, if any time you get caught in either patent infringement or copyright infringement or something like that, the defendant's going to say it's not valid. And again, this is completely off the track, but there's a very interesting case. Every single person writing software today that wants to patent it should read a case that just came out a couple years ago, Citrix v. Williamson, or excuse me, backwards, Williamson v. Citrix. Prima facie case was, hey, we have a valid patent, and you, Apple, IBM, Citrix, you're violating our patent, so pay up. And the first thing that defendants did is said, wait a minute, we are going to attempt to invalidate your patent, and by golly, they did, on a very interesting interpretation of the law. So, prima facie case again, I proved the first 5 elements. Do they mean they're proven beyond any kind of argument? No. It just shifts the burden of proof now to where the defendant is on the hot seat. Now defendant, you have to prove what I've said is not true. Okay, so DMCA in a nutshell. Let me back up. So, talk about copyright. They provided an exemption for internet providers. So in other words, typically in law, if I assist you in some kind of endeavor, I'm going to be held liable. Well, if I'm breaking and violating the DMCA on your copyright, and I'm doing that using Google search, or I'm doing that using Google, or I'm doing that using whoever owns the backbone, Sprint, or whatever, and you don't know you obviously don't know I'm doing this, so that's exempt. So that comes out. However, the biggest controversy on this and the conflict between law and technical is these exemptions are not strong enough. And you will see abuse of this. I have put on the EFF, the Electronic Freedom Foundation, publishes a report periodically about the unintended consequences of DMCA. Read that. Because you will find that even though there are exceptions for like interoperability, research, encryption, research, and other things, no, it's an interpretation. Were you really doing encryption research? Did you really need that for interoperability and the like? Okay, so DMCA 1201, that's all that's in this book. We're not going through the whole DMCA. Is relative to cybersecurity. And 12A1, 1201A1 prohibits the act of circumventing technology that controls access to copyright material. And guess what? We have no argument on this. Everybody agrees with this. Yep, no problem. You know, the only people that don't agree are those that are being caught, criminally or civilly. It's direct. It's not controversial. And, you know, at the time it was passed, as your book says, this was never before made unlawful. If you go back and read the history of computers, things Stephen Jobs and Stephen Wozniak and Bill Gates and some of these people did, if they did after DMCA, would it cost them time in the big house, right? So it had never been made unlawful, and it focused carefully on if they've circumvented technologies to protect copyrighted work. So, you know, your book uses the action as being analogous to breaking into a locked room in order to obtain a copy of a book. Now let's go back to when this was passed. Before the internet and all these other wonderful things that have made our lives interesting, I could steal a book, and then or maybe buy a book, and then I would tear the book apart, and I would copy it, and then I would go out and sell copies, but I'd have to have a distribution, and, you know, I'd have to have an audience, and wait a minute, the book's $50. If I buy it, I'll give you $5, and the like. Well, this was always against the law under copyright law. When we say that the DMCA is based on copyright law extended to the electronic world, the internet just made it easier. I don't have to steal a paper copy. I don't have to copy it. I don't have to store them. I don't have to send them. I don't, all this. I can do it over the internet, right? Makes it a lot easier. Don't have to break that supply chain down. So A1 is pretty straightforward. Excuse me. But he provides a really good legal analysis, and I'm kind of glossing over here, but I'll be happy to, discuss with you at any time ad nauseum, because A1 is not controversial. It's straightforward, and it's prosecuted, and it's basically doing what was done before, but now we're doing it in an electronic era. The problem comes in with A2, which prohibits trafficking in technology that facilitates this, or B1, which prohibits trafficking in technology that facilitates circumvention of measure that protected against copyright infringement. Again, we have a conflict in the circuits, as he explains. Go back to 209, the CAFC, which now you all know, we have that federal court with a jurisdiction on subject matter. They have a very narrow interpretation of this, right? So Chamberlain, they said, we're trafficking a product that circumvents technology that protects it. They are the one that established this copyright test, a 6-element test, which now you know that the plaintiff has to prove a prima facie case on the first 5. Was there a valid copyright on the work? Was it effectively controlled by a technological measure that third parties could access? Somebody for nefarious terms under 4, was that done without authorization to infringe or facilitate infringing on a right protected by the copyright? And if you can prove those 5, then you move on to say, did the defendant design or produce this primarily? Was it made available? Is it marketed? Okay, but you got to prove the first 5 to begin with. Now, the controversy comes in the interpretation of certain words in that law. Okay, so and as I said, Mr. Kosseff goes through, I should say Professor Kosseff, that's what you call him in law school, professor, you know, because they don't really have doctorates usually. And so the Chamberlain opinion was quickly adopted because of its narrow interpretation. So again, you have some federal circuits taking that. Now, so who comes up with the broad interpretation? So in other words, here's our conflict. And in 2010, the Court of Appeals in the Ninth Circuit, ding, 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 where's the Ninth Circuit? San Francisco, Arizona, California, Alaska, Hawaii. We're not worried about the last 3. California, home to Silicon Valley and a lot of technical companies. And they took a very broad interpretation. And they basically said, if you did this, you're going to be wrong. Well, why are they doing this? What is the business community that they serve? Now, be clear, I am not saying the courts are corrupt or that the courts are swayed or anything with that. What I'm saying is when you have appellate courts in certain districts and they see the same kind of cases and they carry experience in those cases, they tend to interpret those cases differently, just like in the Third Circuit in Delaware. Fact of life. The judges are doing what they're paid to do, which is interpret the law. But because they see more of this and because they see so many of it and because they have high-dollar lawyers persuading them, that they had a very broad interpretation. And basically it goes to the words of Judge Scalia, plain language. The Ninth Circuit said, hey, read the law. Federal courts of circuit, excuse me, the court in Washington, the CAFC, you ignored the plain language. And this is about first paragraph, full paragraph on page 2112. And this is for public policy. Now, we've talked about public policy before. It's not so much, I don't want to say it's good for the people in the public. It's basically what's good for society. What is good for society to be economically robust, to survive, to be good? And the fact that you have this very narrow interpretation is not good for public policy, that you are ignoring the plain language. Now remember, these are just the justices and how they interpret it. So if you read this, and he goes into a very detailed analysis, and be my guest to read this from 209 to 215 on this interpretation. And so we still to this day have a conflict in the circuits and how it's going to be interpreted in courts brought before the CAFC and the courts in the Ninth Circuit and the like. It's all different. And that's what you need to know, right? It's a huge divide. So, you know, we like to go to a lawyer and pay him and say, just tell me what to do. And the lawyer starts his, $400, $500, $600, $700 an hour with, well, it depends, right? Well, in this case, unfortunately, it does depend, right? And so the courts are split. That's the best I can say. We have no clear action. And This is going to continue unless it goes to the Supreme Court, which so far hasn't been interested in looking at these cases. Okay? So when we talk about A2 and B1, you might be a little confused because A2 prohibits trafficking in technology that facilitates circumvention of access control measures, prohibits trafficking in technology that facilitates circumvention of measures that protect against copyright infringement. Okay, we're confused. Which is this? And it is true that if you have a B1 claim, you typically will also win the A2 claim. But the reverse is not true. The other thing you want to remember is the difference between you guys, engineers, computer scientists, and lawyers. If I'm a software engineer and I'm researching algorithms to do a certain job and I have 5 different ways to do it, and I pick the best algorithm and I go ahead with that. That's not how lawyers are. Lawyers say, okay, what are all the possible ways the defendant could be wrong? A2, B1, in the civil case it might be, let's sue him under contract, let's sue him under tort, let's sue him under unjust enrichment. Let's throw it all out there, because if the judge says, no, this is not a valid contract, and throws that out, we have other things to fall back on. It's a different mindset. So this is the same thing here. If you have an A2, you're going to have a B1, but not prohibited. But not the other way. So what do I want you to know about this? 1201, relative to cybersecurity. No conflict on A1, straightforward. Conflict on the meaning of A2 and B1. This law is maybe, 20 years old. Every year there's more controversy where the exceptions are not being adhered to. And like I said, until the Supreme Court of the United States sits back and gives us an opinion, it's going to continue. So, as a review, A1 prohibits the act of circumventing technology that controls access, but this is the catcher. Subsequent use, performance, distribution is covered by the copyright laws. So we put something out there on, let's say, YouTube, and I'm just making this up though. It's going to be the original, and I break into something and I put this out. It's going to circumvent the technology. Subsequent use and distribution of it by someone who may say they don't know that is covered by the copyright laws, even though this law does not require knowing and intentionally. Most criminal acts, civil acts say you knew this and you intentionally did this. But this can say, oh, God, I'm sorry. I thought that, I didn't realize that was copyrighted. Now you violated DMCA, you circumvented technology, you did this. But subsequent in that supply chain of supplying that purloined IP down the road is usually covered by the copyright laws. 2008, 10 years ago this summer, I spent 4 weeks in Russia studying law, and my last night there we were walking around, and it was one of these things I wish I had gotten a video of. Some young Russian comes out of a video store, and he starts talking gangster talk because he thinks that's all cool, and I get to talking to the video store owners and said, you really need to let this guy know if he ever goes to the United States, not a good idea to use that term, on women and stuff, but anyway, the owner says, hey, what movie do you want to see? And I can't remember what the blockbusters were out in 2008, but tell me what movie you want. I got it. And he did. He had any movie that was playing at that time, blockbusters in the United States, he had. And he explained to me that even though they were on CDs and it was a different type than the CD players we have in the U.S., he would throw in a free CD player. And man, it was such a good bargain. Didn't I want to get this? And didn't I want to show it to my friends? And didn't I want to do this? And didn't I want to do that? And my friend and I, who was with me, was also in the law group. And, we both kind of laughed and said, yeah, this would all be well and good until we came through customs. Not going to work, right? So, this whole thing is we don't realize a lot of times a lot of this IP outside the U.S. is there for the taking, there for the asking. All right, now A2 prohibits trafficking in technology that facilitates circumvention. As I said earlier, 209 to 215 is a complicated legal analysis. I don't want to shortchange you. If anyone would like to sit down and go through this, I'll go through it. I'm as good a lawyer as the next guy. I can say it depends, and if you want to pay me big bucks, just kidding. But what we need to know is there's a disagreement between the federal circuits. And as of today, still not resolved. And B2, it's similar. The differences are not important to this course. I just want you to know that the law exists. Let's talk about the potential penalties. Civil and criminal. A plaintiff can seek injunctions. Injunctions are very powerful. An injunction says, hey, you have to stop what you're doing. Well, wait a minute. I haven't had my day in court. If I stop what I'm doing, I'm going to go bankrupt waiting for my day in court because I won't get sales. Well, too bad, too sad. I've made a prima facie case to the judge, and I've convinced him to issue an injunction to stop, cease and desist in what you're doing. We used to have this in patent under the old law. Patent trolls used this very effectively when BlackBerry was pervasive because of their security throughout Congress and the government. They were sued for Research in Motion was sued for patent infringement by some patent trolls. And basically the patent trolls who were lawyers said to BlackBerry Research in Motion, hey, we're going to go get the judge to issue an injunction because that is the remedy of choice, and you're going to be out of business unless you give us $519 million to drop the suit, which they did. They capitulated, and that caused such a stir that the injunction was removed by the default penalty now under the new patent law. However, 1201, you can still seek an injunction. And we're going to see in a few minutes on a case where that kills you, okay? The other things in this chapter are about the exceptions. The exceptions are nonprofit libraries and, educational institutions, including Texas A&M and law enforcement intelligence agency. The ones important to you are the reverse engineering for interoperability, encryption research, and security testing. And this is all a gray area because there's always an argument on each side. So you see that the EFF has a paper. I want to make this point about it. EFF's great, Electronic Freedom Foundation. Our table is big enough that we need to have all different kinds of voices in our cybersecurity world, whether we agree with them or not. It's a leading nonprofit defending digital privacy, free speech, innovation, but it has no legal power. The number of times someone has brought something to me, well, the EFF, yes, they file what's called a friend of the court in a lawsuit, amicus brief, hey, I'm a friend of that, and I'm going to, judge, I want to have, permission to give you this paper for you to consider when you're making your ruling, because we may know things you hadn't thought about, but they have no real legal power. They are an interesting voice. They get a lot of attention. We need to have them in our society, but, they have no legal power. Okay, so let's talk about, did I finish everything on this? Let's talk about two important cases. And these are older cases, but I can give you a list about 16 to 20 cases if you're interested. I kind of like these two. This was early in. Sega was the big game playing machine, company. This was in the Ninth Circuit in California because they were a California company, and some little company called Accolade started developing video games to play on Sega players. And so they took access to copyrighted software code for what we would possibly call interoperability, which is an exception. The district court went for Sega and they issued an injunction against Accolade, and they drove them almost to the point of bankruptcy. While it was in appeals, the circuit court went for Accolade and they said this is fair use. Public policy says, Sega, yeah, you built the game playing machine. Accolade's just, all they want to do is be able to sell games to play on your machine. They're not manufacturing the game playing machines. And the circuit court was so incensed by what they considered that Sega had caused so much confusion in the district court for false labeling that they assessed all court costs, including Accolade's legal bills, to Sega. And this is almost unheard of in the U.S. We go by what's called the American rule. Winner or loser pays the legal fees, right? I was in a serious car accident some years ago. I did file a suit, but they settled out of court. But I still had to pay my lawyer 40% of what I got, regardless, right? Even though I won. Now you're going to say, but Texas has this law. Yes, Texas passed a law a few years ago that the judge, at his discretion, can order legal fees to be paid by the loser, but it's not a given. Now, the dumb thing is, and I say dumb, and I know last night my 6-year-old granddaughter caught me saying the word dumb and said, hey, that's a bad word. And I thought, yeah, I know some worse ones. But it is a dumb thing, because when you go to court, it's going to take years. It's going to cost money. This type of litigation, patent infringement in this today, $2 to $5 million. You want to sue me for patent infringement? You got $2 million sitting in your bank account. I think a better approach is what Sega, while this was going on, eventually licensed to Accolade. And then, guess what? It's the American way. Accolade developed profitable games and paid Sega royalties, and they both made tens or hundreds of millions of dollars, right? So keep this in mind. Patent litigation. I'm going to sue you because you're infringing on my patent. Well, I think you are. You think you're not. We go to court. We both spend a lot of money, both spend a lot of time, both spend a lot of focus away from doing our business. But hey, what if I said, hey, I don't know if I'm right. I don't know if you're right. Can we come to some kind of mutually acceptable license agreement that we're both going to make money? A second interesting case you'll hear referred to is US v. Elcom. He was a Russian. He came to DEF CON. He spoke, and as he's getting ready to fly out of Vegas to go back to Russia, he's arrested in violation of the DMCA. The case raised some issues of civil rights and legal process because they not only arrested him, but then they put him in an immigration hold, I think someplace in Oklahoma. Like, it was like, seriously, guys, I mean, this is a hacker type dude. He's not, he's not coming across the border. It got to the point where people were going to boycott Adobe because what he did is he basically figured out a way to unencrypt PDF files to violate copyright provisions. Now, here's the interesting point of the law. The crime was fully legal in Russia, meaning whatever he was breaking wasn't copied. The copyright law was not under U.S. copyright law. So if he took that and violated Adobe's copyright protections, Adobe didn't have the copyright on the material. But when he got to the material, it didn't come under U.S. jurisdiction. Remember, DMCA is based on U.S. copyright law. So in other words, yes, he did this, but what he was doing wasn't illegal in Russia to get to that material. They dismissed the case. Adobe at one time, they were doing demonstrations outside of their headquarters. It was almost comical in today's, this has been some years back before they said, come on, get real. But these are two cases. Like I said, if you're interested in this, make a great paper topic. I got 16 or 20 cases that'll just get your eyes spinning in both directions. It's an interesting part of the law. It's a long chapter. You got video 1 and video 3 uploaded, and now video 2. Thank you, and I'll look forward to talking with you soon.